evening and welcome to KSFY This Week. I'm Mitch Krebs. We're continuing our look at some of the issues that you'll be voting on November 7th. And tonight we're going to look at video lottery. Voting on that again, that's coming up a little bit later in the broadcast. But first we're going to talk about Constitutional Amendment C. And the wording of this is South Dakota statutes currently limit marriage to unions between a man and a woman. However, the state constitution does not address marriage. Amendment C would amend the state constitution to allow and recognize marriage only between a man and a woman. It would also prohibit the legislature from allowing or recognizing civil unions, domestic partnerships, and other quasi-marital relationships between two or more persons regardless of sex. A vote yes would change the Constitution. A vote no would leave the Constitution as it is. That's our first topic tonight. And joining us now is Rob Regier from the South Dakota Family Policy Council. Rob, thank you for being here. And John Hoadley from South Dakotans Against Discrimination. John, thank you for being here as well.
And thanks for having me.
Start with you on this one, Rob. When people go, we just heard the way the amendment is listed on the ballot, and that's what people are going to look at. But as these issues oftentimes are, there's a lot more to it than might be listed in that one paragraph. What do you think are the most important things for each voter to do their homework on beforehand and to think about when they go into the ballot box and when they choose to vote pro or con on this amendment?
Well, we just saw a couple days ago what the state of New Jersey did. Their Supreme Court went ahead and directed their legislature to give the rights and privileges of marriage to people who aren't married, to homosexual couples. Whether they call it marriage or civil union or domestic partnership, that remains to be seen what the legislature does there. But if South Dakotans want to prohibit our state judges from doing something like that in the future, and gay activists have made it pretty clear that their end goal is to marry people of the same sex here in South Dakota. If we know what their goal is, and we've seen them being successful in other states, I think it's important now to take care of this in the Constitution to prevent some activist judge from gutting marriage like they did in New Jersey.
All right, John, same question to you.
Well, I think what's important to remember about the New Jersey ruling, since we're starting with that, is that the court actually didn't grant gay marriage. In fact, we've had losses in that sense in New Jersey or Washington and now in New York as well. And the situation in New Jersey just said that you had to treat people equally and fairly. And I think that's what the problem with Amendment C is. It's a law that goes too far. It adds a term called quasi-marital into our state constitution, which isn't defined, and it's going to force judges to decide what sort of laws or benefits have an effect similar to marriage and then deny them to all non-married people. Now, this is going to affect both straight and gay people in South Dakota. And the problem with that is it could affect people like our seniors, or women who are currently protected under domestic violence laws that could lose those. If we want to talk about other states, we should be looking at, like New Jersey, we should be looking at states that have had similar laws to South Dakota, like Ohio, and look at the real mess that their amendment has created for them.
When looking at this this amendment and what we're voting on, I guess one way to look at it, you could look at there are some social ramifications, social reasons for doing this, and then there are the legal things, the nuts and bolts of how the law would work, and maybe we could address those one at a time and start with the legal part of it. There is some argument out there that you don't need a constitutional amendment like this because there's already laws on the books that affect things like this and are aimed at some of these issues that are brought up on both sides. Your thoughts on that, John?
Well, I think 10 years ago, South Dakota settled the question about what marriage is in South Dakota. It's between a man and a woman. The problem, though, is that Amendment C goes out of its way to take any sort of other legal relationships or compromise off the table. That's why this goes too far. Because what it ends up doing is saying that if you're married, you get one set of benefits. But if you're a family that's not married, a gay family, or a senior citizens who live together but they cannot remarry because they lose their Social Security or pension benefits by getting married, these are the people that are going to be affected by it. And that's the real problem.
The legal parts of it from your perspective.
Well, I think what John mentioned is equality. The 8th Circuit Court of Appeals that covers the state of South Dakota said that the 14th Amendment was never meant to treat unmarried couples the same as married couples. Two men together are not the same thing as a man and a wife. State after state, every state in the Union until just recently treated couples that way. What New Jersey did, they gutted marriage by saying to the legislature, you have to grant all the rights and privileges of marriage to people who actually aren't married, whether they be two men or a man and a wife or a man and 10 women. And what we're doing here with this amendment is protecting it in the Constitution so that some judge or even some legislature somewhere down the road doesn't decide it's a good idea for men to be able to marry men. Let's take care of this issue now while we can before it's too late.
All right, John?
That's the problem, though, when we're talking about this. Rob is going out of his way to mislead people what actually happened in New Jersey and about Amendment C in South Dakota. The problem with New Jersey is that all their decision said is, in fact, they went out of their way to say that they're not going to give marriage to gay people. They couldn't find a right in the New Jersey Constitution, the second most liberal court in the country behind Massachusetts. And if anyone thinks that the New Jersey court is the same as South Dakota court, I'd love to see them make that comparison. But what that said is that when it comes to things, the way we treat people, being able to make medical decisions for someone, or being able to care for someone when they're sick and take those personal responsibilities as couples, that it's not fair to say that only married couples can make those arrangements. And we need to be able to have sort of equal protection for them. And that's what the problem with Amendment C is. It goes out of its way to say that we can't make sure that people can take that personal responsibility for themselves in South Dakota. Because what's going to happen is, quasi-marital could force judges, whether they think it's a good idea or not, to invalidate contracts that are between two private individuals. Because if the judge rules that the set of relationships in total between those people are deemed quasi-marital, then they'd be unconstitutional. That's the problem when you change a constitution. It changes all the other laws in our state as well.
All right, Rob, any response to that before we go to break?
Well, I think it's the sky is falling scenario. Those things aren't going to happen. The people are still going to be able to draw up living wills, powers of attorney, make private legal arrangements. It's not going to affect private living arrangements. Things will be the same after this amendment is passed as they are now.
All right, when we come back, much more on the social implications of constitutional amendment C. Stay around. Stay with us. We'll be right back.